And the Constitution doesn't lose its power simply because law enforcement is inconvenienced by the dictates of the Fourth Amendment. We've been talking about privacy and how the Fourth Amendment protects people, not places. But sometimes the privacy at hand is a person, and the government's attempts to intrude into the body constitute a search. The body represents the most intimate constitutional boundary. It is the core of personal privacy, and intrusions into the body are highly regulated. The government can search your car. With a warrant, it can search your house. But the plain language of the Fourth Amendment includes protection of the person. And when it comes to the body, the Fourth Amendment has a different boundary. It is physical integrity. It is autonomy. It is dignity. The closer the government gets to bodily intrusion, the stronger the constitutional concern. Not all body intrusions are treated the same, however. Today, we're talking about how the Constitution responds when privacy becomes personal. Today, we're talking about what happens when the Constitution stops protecting what belongs to you and starts protecting you. My name is Shelley Behan, and this is Fourth Amendment Friday. The court has created a hierarchy of analysis when it comes to body searches. It considers the extent of the physical intrusion, the level of invasiveness, and the privacy interest involved. And DUIs are right at the heart of the discussion. On the lower end, there are breath tests. Minimally intrusive, no physical penetration. On the higher end, blood draws, physical penetration, and extraction of biological material. But blood just doesn't reveal only an alcohol concentration or drug content. It contains a tremendous amount of personal information about the person subjected to the search. It can reveal diseases, genetic traits, familial relationships, medical conditions, and pieces of your life that have nothing to do with criminal activity. It is profoundly personal. So the court balances the government's interest in searching your person against the level of bodily intrusion to determine reasonableness. Think about it like this. As you know, the government can get into your car, can get inside your house in some circumstances. With the proper paperwork, the government can go through every single part of your phone. But drawing blood means the government is crossing into territory that literally lives inside you. Okay, let's pour some legal on it. In Schmerber versus California, blood was drawn without a warrant in a DUI case. The court looked to the exigent circumstances exception and found that given the time period of the case, it would take way too long to get a search warrant, and alcohol would just dissipate in the bloodstream while the officers were waiting. The case recognized blood draws as a search, but only allowed a warrantless blood draw under a limited, case-specific exigency. This means that at the time of Schmerber, bodily intrusion required a strong justification. Remember, one of the exceptions to the warrant requirement was an exigent circumstance, meaning we are going to lose evidence if we wait for the warrant, so we have to act now. And for years, officers drew blood without a warrant in reliance upon the Schmerber decision. It wasn't until Missouri versus McNeely that the Supreme Court said we refuse to recognize a per se exigency for alcohol dissipation in the blood. This case rejected the government's argument that because alcohol in blood is always dissipating, this provides an automatic justification for that warrantless search, and instead set the standard that a case-by-case exigency analysis is required. When Schmerber was decided, getting a warrant could take hours. Today, it happens in minutes. And the Constitution doesn't lose its power simply because law enforcement is inconvenienced by the dictates of the Fourth Amendment. As McNeely famously stated, in those instances where officers can get a warrant, the Fourth Amendment mandates that they do so. On the heels of McNeely came Birchfield versus North Dakota, which is a case that differentiated between breath and blood for Fourth Amendment purposes. According to the court, breath tests are non-intrusive, consists of blowing into a tube, and can be classified as searches incident to arrest, able to be executed without a warrant. But putting a needle in someone's arm, that is an entirely different constitutional circumstance. This case created a constitutional hierarchy of bodily intrusion. The Constitution draws a line at the body, and it runs through your veins. When we add these cases together, we can see that Schmerber allowed the exigency, McNeely rejected an automatic exigency, and Birchfield formalized the difference between breath and blood. The body is a constitutional stopping point. The court imposes limits, and there is no bodily intrusion without strong justification and procedural safeguards. Even considering the high government interest in pursuing DUI investigations, the court balances public safety against individual autonomy and found constitutional support for protecting a person's privacy interest in his or her body. If the right to privacy is anywhere, It is the body. And every case that crosses bodily boundaries forces the court to again look at how far the Fourth Amendment really goes. We spend a lot of time talking about privacy in our homes, our cars, our phones, and our data. Every single one of those things exists outside of ourselves. But the most private place protected by the Fourth Amendment is the human body. The Supremes have spent decades establishing that boundary, sometimes imperfectly, sometimes inconsistently, but the court has always come back to one simple truth: there is nowhere more personal than inside your own skin. And that does it for this week's episode. Tune in next time when we will be talking about privacy and data exposure. Until then, stay free, stay fabulous, and remember your fundamentals. My name is Shelley Behan. I am the host of Beyond the Breathalyzer, and your rights are my priority.